So, good morning, everyone. Welcome to ILA session. As Madhura said, today is the most interesting topic as we recently had our election results. So, Mr. Chuk will be joining soon. Uh, till then, I'll uh, go with the questions. Uh, so, for Nikhil, can you give your introduction first? Hello, Nikhil. Am I audible?
Yes, Durga, you are audible. Do we
Mhm.
want to maybe move to the next panelist until Nikhil connects?
Okay. So, good morning, Sumesh.
Yeah, hi.
Uh,
Morning.
yeah, hi. How are you doing?
I'm good. Hi.
Good. So now I would like to ask you, how could the new political dynamics influence the appointment of judges, especially the higher judiciary? What are your views on this?
Yeah, hi. Good morning, everyone. This is Sumesh Chaman, the managing partner from Lex Fabios. So typically, the new political dynamics gonna be having a sea change because the last 10 years we've been seeing the BJP government in power, which had a majority, and typically now as the new government, obviously we have BJP coming back to power, but not with its own majority, but with a coalition government. So that's gonna have a big influence because typically the government tried to bring in a judicial accountability bill and a judicial reform bill in his first term, which was struck down by the judiciary. So there's always been a tussle between, despite the government having a majority for the last two terms, you've been always seeing a tussle between the judiciary and the legislature, where the judges' appointments has been a key issue, filling of vacancies, the quality of judges, or the names of the appointees, where the government's been taking very long in and has been rejecting, and where the so basically the whole collegian system, which obviously a lot of former judges have also said is a little flawed system, and the governments and some part of the judiciary has been trying to bring in a new system where there is more transparency in the appointment of judges. But now with the change in political dynamics, where the BJP doesn't have, the government doesn't have its own majority in the Lok Sabha, so bringing in a new legislation and creating a consensus between their own, leaving apart the opposition party, even creating a consensus amongst its own coalition partners, may be a big challenge, and especially keeping in account the throwback from the judiciary and pushback. But yes, definitely the reforms are a priority of the government. But let's see how far the government is, because there is part of their agenda, and it's been part of the government's priority to bring in a judicial accountability bill to have a more transparent system in appointment of judges. But surely the lack of a majority in the Lok Sabha and the lack of majority will, unless the government is able to build up consensus among all political parties, it will be very difficult. At least personally, I feel that a law or a reform like this will come into place very soon.
Yeah, thank you for that. Uh, One more question, Sumesh. Given the current political landscape, what challenges do you anticipate in implementing these reforms relating to improving access to justice, reducing pendency of cases, or enhancing judicial accountability?
So the government again on its agenda had made it very clear that they had a whole list of reforms in place. The government has always been the BJP government or the government in power for the last 10 years has very much been on a forefront to bring in more judicial reforms. And but typically, the reforms such as one obviously is a long call of setting up regional benches of Supreme Courts because the apex court only being in Delhi and not and there's been a long demand that typically cities like Chennai, Hyderabad, Kolkata, Bombay can have some regional branches of apex courts and which can hear non-constitutional matters. And then one of the biggest reform areas which I think the government's gonna push, and there's also been, I believe, a legal consensus from the judiciary side, as Justice Chandrachud also said recently, that an alternate dispute mechanism needs to bring in place, wherein a timeline, how cases are decided and how quickly the cases can be defined, can be settled in a defined timeline, is very much imperative. So, because we had a mediation bill coming in a couple of years back, which said all commercial disputes must go to mediation, and it has been acknowledged by the government and even judiciary. Justice Chandrachud and other judges have acknowledged that that's been a big failure because it has only led to, instead of fast tracking the commercial disputes, it has led to more delays because you have a 6 months to 8 months buffer before you can actually start a recovery proceedings or a commercial proceedings. So the new mediation regulation of 2023 is probably a big piece of legislation which will, provide seamless like a standalone regulation on mediation and bring in a new culture. But this is something I personally feel that because since judiciary and legislature are both are very much in consensus in bringing in a new ADR mechanism, so that should be something we should see very soon. Then in addition, there is a lot of push for, again, on infrastructure and technology. The judiciary, of course, has gone a long way since COVID, where we have e-filings, we have virtual hearings, but that's pretty much restricted to the metros or the bigger cities. When you go to smaller cities, still, the physical appearance is a norm. And also we have still e-filing is followed by a physical filing and objection where it takes sometimes a lot of delay in not only instituting or filing a case, but leave alone like judges hearing of matters. And so typically, as again, I think that's another reform where judiciary and the government are very much on the same page, where the infrastructure has to improve, new technology has to come in. We are living in a world of artificial intelligence where judiciary in US and all have adapting AI. They're going into a very different level where we are still trying to grapple with the basic technology access on a pan-India basis. But again, the biggest challenge that we see is the funding amount, because the question always comes, who will spend the money? Because the central government may be willing, but since when it comes to actual infrastructure for judiciary, it becomes a state subject also. Each state government is supposed to, build more courtrooms or provide more, funds for improving the judicial infrastructure. So that becomes a pretty much challenging. And then, of course, as we said, as I said earlier, the appointment and accountability of judges is a big question mark, because at times we have a amazing system which is called a collegiate system where judges appoint judges, but there is still a lot of lack of accountability. And last but not the least, you have a whole backlog of cases. So I think probably even neither the judiciary nor the legislature have addressed the big issue, which has been burning issue for the last 25 years. How do we remove the backlog? I believe I was reading somewhere there over 51 million cases which have been pending for the last 30 years. So, of course, having more judges, having more support staff, having more filling up all vacancies. So these are something I think the government would, I believe, would be a big thrust on judicial reform. But again, as I lastly, I'd like to add, with the coalition politics and with their own allied partners may or may not be on board with the government.
But Sumesh, what is the deal that we can't even do the simplest of things possible that would make a huge difference? For example, I was speaking to a judge one day in India, and he said, I have 600 cases tomorrow. I'm going to hear 30, 40 of them and continue the rest. And I have to go home and read hundreds of pages. And one of the pleadings is 400 pages long. And I'm like, why do you not have a page limit in the rest of the world? Almost every court in some countries, lower court, middle court, high court, criminal matters, IP matters, corporate matters, litigation, family law. There's page limits. One
I
appeal
agree.
court that I work with has a 70,000 word limit. And when we prepare the appeal, on top of it, we have to sign a certificate that I have ensured it's less than 70,000 words. One more word than 70,000, the appeals court is going to kick back the appeal, and there's 60 days to file an appeal. And if they kick it back and you don't have the 60 days, within 60 days to file again, you're screwed. So the judge
I
says to me,
absolutely,
so
yeah, I
Sumesh,
agree.
the judge says to me, is this in writing, the page limit? And I said, of course it's in writing. The Code of Civil Procedure, the federal court, this, that, everything is in writing. And he says to me, send it to me. And I'm like, what? India is a 75,000-year-old civilization. There's 21,000 judges, 1.4 billion people, 1.5 million lawyers, and some person in some other foreign country has to send you rules. And I thought he would get offended, so I didn't send it. So a week later, I get a text, WhatsApp, Mr. Chug, where are the rules? I'm like, okay, this guy is serious. So I sent it. But, and so one other lawyer I said this to says to me, well, that's not justice if you're not letting people talk. And I'm thinking 400 pages pleading, whatever is in 400 pages can very easily be in 40 pages or 10 pages. And it's not that you're stopping somebody from justice so they can't write enough. We're not doing justice because the judges are reading nonsense. So why can't we do a page limit?
No, that is, I think, a much needed reform because unfortunately, on a hilarious note, we as especially the litigation lawyers are taught that, if especially as young lawyers, the young lawyers are told, if you work with a litigation chamber, if you draft a reply of 5 pages, your senior's gonna throw you out. It's like, the bigger the reply, it may be probably repetition of the same thing in a different way. But unless you make a 40, 50 page reply, so, it's not appreciated. And again, so the culture, I think, is a cultural issue, and also not only the pages. I believe the judges should allot timelines because the senior counsels get away with arguing matters for. Of course, they are we have some of the finest lawyers, but they can argue for hours and hours, and then after 3 hours of argument, they would say, "Your Lordship, I would like to continue my arguments on the next hearing, which is 3 months away." So a year elapses where a counsel is only arguing his matter. Kulwant wanted to say, yeah, please.
Durga, carry on. Durga.
Yes.
Please carry on.
Yeah. Yes, sir. Sumesh, thank you for your insightful views on this. Now I would request Nikhil Mehta, sir, to introduce himself.
Hello, sir. This is Nikhil Mehta. First of all, good morning to all of you. As now, I'm a practicing advocate here in Jharkhand. I used to practice in High Court and all other courts also. Yes, sir.
Thank you, sir.
So,
Hello.
Nikhil, are you happy with the election result?
Sir, the election result, yes, sir. I'm happy with the election results because giving ultimate power brings autocracy. And by coming autocracy, some rules and other things which are passed unilaterally, which should not happen.
So, of the 100 people that got us independence, I think 75 of them were lawyers. And then we got the country independence but then we were inside the prison and we threw away the keys. So the rest of the country is free, but the lawyers of India are still in prison. We cannot advertise, we cannot have a website, we cannot have a booth at a conference, we cannot take matters on a contingency basis. A country that doesn't allow lawyers to take matters on a contingency basis is a country that has a sign outside that says no justice for the poor, because the purpose of law is to protect the powerless from the government and the powerful. And the only way the powerless have power is through judiciary and courts and lawyers, and they can't afford attorney's fees. So the only way the poor around the world get justice is through contingency lawyering, and our country's banned it. And because we're not allowed to advertise, we can't let the poor know what their rights are. And because we can't take matters on a contingency basis, we can't help the poor. And because we can't help, we don't have enough work. And so how come a plumber can advertise, but we can't? So when are the lawyers, you think the new government will do something to get the lawyers out of prison?
See, Navneet, the
Sure.
challenge is, sorry, is Sumesh, but the unfortunate part is because I have also been very much part of the government trying to work on judicial reforms and entry of foreign law firms. There is no one knows who's responsible because
Right.
you have a Bar Council of India, you have a Supreme Court, and you have a government. So when you talk about what you rightly saying, I have been a forefront on this issue of advertising for lawyers and some change in, because these are rules, these are embracing the Bar Council rules. Now the Bar Council rules can only be amended by the Bar Council. But now the Bar Council comes up 2 years back with some sort of regulation for entry of foreign law firms, which is now pending again before the Supreme Court. Because the government says, no, the Bar Council doesn't have a power. So the challenge we are facing, because the irony is after 70 years, we are not even aware that for lawyers, who will make the regulation? Will it be the government, the judiciary, or the Bar Council? So I think
Nikhil, what do you think?
So, first of all, justice for all here, actually, the people, especially in the rural areas or the downgrade. I don't want to use downgraded. The people with lower income segments, they are mostly are not aware that their particular services are provided to them at free of cost. Like there are institutes like DALSA, which District Legal Service Authority. At higher level, it's high court. High Court Judicials, and in central level, it's NALSA, where they are used to get free legal aid. They used to get counsels appointed, which are paid by the government, the state. Here, the lack of awareness is also something missing for the poor peoples, which should be promoted. And second thing that with regard to advertisement and all, yes, we somehow face a challenge that how we should advertise ourselves. It's not only the Bar Council, because it's the government also. Because many of the members of our bar are part of the government or part of the parliament, where they can bring up these issues. But they are not willing.
Okay, good. Durga, go ahead. Next panelist, next question.
Yes, sir. Sure, we'll do that. Yeah. Nikhil, sir.
Yes. Hello?
Yeah.
Yes, ma'am.
Nikhil, sir, what do you think the step should be for the legal community to take to ensure that the interest of marginal communities and vulnerable sections of society are safeguarded under the new political dispensation?
Ma'am, the only thing is marginal peoples. Here we have to bring legal awareness, because there are a lot of lawyers who are here who are willing to work at at less fees, or the government is providing them the services, but they are not aware of that these are the services which we will receive from the end of the government or from the other lawyers. Because what happens with as earlier said from our friends, the lack of judgments, very few people know about the other lawyers because they are not allowed to advertise themselves. And
Okay.
Thank you, Nikhil. Durga, next.
Yeah. So, Nikhil, sir, I want to ask one more question. In what ways can the legal profession adapt to and influence the policy shifts expect from a new government to ensure a fair and just legal frame in India?
first of all, as I earlier said, many of our members, means advocates, lawyers, are part of the parliament also, part of the ruling government also. Here, we need certain judicial reforms also, like like one appointment throughout the national. That is national judicial reforms should be there in appointing the higher judicials. More number of judges at lower level means at the lower courts should be appointed because what happens, the burden of cases per judge is much higher, which could not be copped up by saying that they work for 12 hours, 10 hours, less holidays, which will not. The government should appoint more number of judges, more number of benches should be constituted, more number of courts should be opened.
Okay.
Because by burdening a single judge with more number of cases, more types of cases, which is not going to help us.
Thank you, Nikhil.
you.
Durga.
Thank you. Yeah. Now I would like Ojasvita Srivastav to give her intro and then we'll ask her the questions.
Thank you,
Hello.
Durga.
Yeah.
Jaswita. I'm the General Counsel for Securitas at Africa, Middle East, APAC, and I also run an NGO called Project Abhimanyu, which is basically into legal education and guidance for first-generation lawyers. Happy to be here. Thank you.
Thank you. Thank you. So, Ojasvita, with the new government formation, what changes, if any, do you foresee in the rules governing foreign lawyers and law firms practicing in India?
So with the new government coming in, there isn't really much of a change as far as legal policy or for that matter, policy making is concerned, in my opinion, because the same law minister continues and the same government also continues with the majority. So it is the same policies. I think that will be furthered. I don't see any reason for them to change. None of the coalition partners that the India needs right now has any different opinion, or for that matter, any opinion on how lawyers and legal profession should function. I think it's only BJP that has the kind of a mindset that they want to open up India, and that's what was mentioned earlier, that there is now this push for foreign law firms to come in. But I agree with what the earlier panelists said. Both Nikhil and Sumesh, I think a lot has to happen in terms of amendments to the Advocates Act. Things like advertising, things like education for lawyers, like Indian lawyers, once they graduate, don't really get any structured training before they enter the profession. After you graduate, you write an open book exam called the bar exam, and then you become a lawyer. You don't really have any requirement to get trained, which is the norm, which I'm sure Mr. Chugh would see based outside. You have a 2-year training contract, or at least a year of training that a lawyer goes through. And that trains you, that equips you with what are your skills, professional and soft skills that are required to become a lawyer, and not just left to yourself, like it is in India. So I think a lot needs to be done by BCI in that direction before we open up. Because if we open up without it, all the cream, I believe, of our profession, of our colleges is going to get absorbed, and Indian law firms are going to struggle for good talent. Also, I think we need to start moving in that direction where Indian law firms start thinking about going abroad and competing in other countries. Why don't we have a multi-jurisdictional Indian law firm that's competing with a Magic Circle or an international law firm? So I think that mindset change has to happen beside whatever is required under the Advocates Act and the BCI's front. That's my 2 cents. I see, Mr. Chugh, that you're speaking, but you're on mute, so we can't hear you.
So Ojaswita, with 1.4 billion people, I think it's difficult to run the country from one city and a few people. And I think if we're to succeed, we have to decentralize and distribute the powers to the states and districts and cities. So the fact that we have 50-some million pending cases, half of them the government's either plaintiff or defendant, a quarter of them are criminal matters. The Supreme Courts of other countries in the world have less than 100 pending cases. The Indian Supreme Court has 70,000 pending cases. So if we distributed some power to the states, maybe 1 or 2 or 3 or 4 states would clean up their act and clean up the judiciary and set up rules. Like there are a lot of countries that have rules that if a case is not tried within X number of years, it's thrown out. And I think the oldest case in India is from 150 years old. A lot of jurisdictions around the world, cases in Denmark, when you file a case, you get a trial date within 90 days. And a lot of countries, a lot of jurisdictions, if the case is not tried within 3, 4, 5 years, the court throws it out in favor of the defendant. So what's the deal? You're in Haryana, right?
I'm based in Gurgaon, yes.
Does Haryana have a law minister?
So I'm sure it does, but I'm an in-house lawyer, so I'm not practicing in the courts.
Right. But that's the
yes.
issue, right? When I ask lawyers in India, does your state have a law minister? And I've never gotten a straight answer, because either there isn't one, or there is one and they're not doing anything, or they're not out meeting with lawyers or showing up at conferences and talking or having discussions on how to clear the backlog, right? So a quarter of the 50 million pending cases are criminal in majority of the developed world. So criminal matters, when somebody is charged with a crime, they're supposed to show up in front of a judge within 24, 48, 72 hours for a bail hearing. And 2 months ago, the Supreme Court of India scolded the High Court of Mumbai that why is a bail hearing taking 4 years, right? So in a majority of the world, the developed world, criminal matters are given preference because somebody's life is on hold. And because that somebody's life is on hold, their entire family's life is on hold. And there's plea bargaining, right? So a lot of the developed world, 90% of the cases are criminal matters are discharged on plea bargaining. And in India, we have less than 1% on plea bargaining. So if you were made law minister of Haryana or Ojaswita, what would you do?
Okay, a number of points that you mentioned, Mr. Chugh. So on the one hand is whether we need to give the power to decide rules to states to reduce the number of cases, like we said, instead of having. I don't think that will make much of a difference, given that it's not really a question about, having the right power to make changes. It's more about having the interest or having the intention to reduce and to have those kind of rules. Nothing stops the federal government from making rules like this to have a limited time period. In fact, we did make some changes in the Arbitration Act. We made that there has to be a time-bound, completion of arbitration. Unfortunately, despite that, it's still continuing. We get extensions and we don't necessarily finish it. I think there are a couple of tribunals within India, like the Telecom Tribunal, the TDSAT, that actually finishes, matters in 6 months. So there are examples. But then our population is so big and the number of judges are so low. I think one issue is that we don't have enough judges. Secondly, you are absolutely right. We don't have the rules to mandate that you have to finish a case within a certain amount of time and that, you cannot continue with that case forever. Thirdly, I think nobody seems to have an interest as far as a law minister is concerned, or for that matter, BCI. They're not really concerned about reducing the number of cases or in making sure. I mean, there has to be an intention for it. There has to be some lobbying done for it. There has to be somebody who should benefit out of it. I think that part is sort of missing in our country. And in my personal opinion, a lot of the bodies, associations that are there that should have been concentrating on or should have been working towards it are pretty much concentrating on their private interests and what is for them to benefit, which is why things like this are on the back burner. And that's my personal opinion. Like I started with a caveat that I'm an in-house lawyer. But this was, I mean, I started my career with litigation, so this is my opinion based on that.
Do you know how much power you have as an in-house lawyer? So when you're dealing with outside counsel, tell them that if the pleading is more than 10 pages, you will not pay for it. Have you ever tried that?
So to be honest, as an in-house lawyer, and I look after 16 countries in this region, I try my best to avoid litigation or arbitration in India. And I advise my team not to try and get into litigation in India because we don't know how long it will go. If I have an option to arbitrate, I would rather arbitrate outside India in a SIAC or an ICC. At least I know within how much time I'm going to finish the case. So, and I don't think I would blame it on the lawyers either. It's not their fault. If I give a case to Sumesh and the system is such that it takes 5 years to get a case done, it's not Sumesh's fault. Yes, I can push him, but how much can he really have the power to finish it if it's not an urgent matter, if it's not something like a criminal matter, if it's not somebody's life and death? If it's a property case, it's a real estate case, unless you're ready to go down different paths. I don't think there is any way of making sure that your case gets heard and completed quickly.
Every time I handle a case at my office, I get a lawyer to do the litigation and fighting, and I call another lawyer to my room and say, hey, don't talk to this other lawyer at the office that I gave this case to, but I need for you to settle this case parallelly. And so as general counsel, you could say, I don't want to see a pleading over 10 pages. I need this done through arbitration and mediation, and I need this case settled in 1 year. And if you don't settle in 1 year, I'll fire you. And maybe pick up the phone and call the opposing side and opposing counsel and arrange a lunch or dinner meeting. So Justice Kothari. Yeah.
Before we move on, Mr. Chugh, there's 2 points that I would like to add to that. One was on the brevity of our pleadings. I think this is a very important issue. 1960s. The plain English movement started. If you go back to what Lord Denning wrote in the last chapter, we need to try and keep our pleadings as short as possible and, be more to the point. Unfortunately, that has still not reached our Supreme Court, has still not reached the Indian judicial system. You still have hundreds and thousands of pages that are running. On the other hand, the Supreme Court of EU literally gives a maximum of 4 or 5 pages judgment. So I think that's a cultural thing that is going to take time. And on settling of matters, I would really like to understand, why do you have 2 different lawyers for settling of the matters? Whoever is handling the matter should be the one who should negotiate and settle down, and that's what we go for. But that was an interesting point from you.
Let me read to you the United States Supreme Court pleading rule. Every document must be prepared in a bound booklet format on a paper that is cut to 6 inches by 9 inches. The paper must be opaque, unglazed, and not less than 60 pounds in weight, and shall have margins of at least 3/4 of an inch on all sides. The text field, including footnotes, may not exceed 41/8 by 71/8 inches. And the font size and everything and number of pages. So, it's just somebody has to do it. And if the judges aren't going to do it, and if the government's not going to do it, and the law ministry is not going to do it, then the lawyers need to make a noise. And Indian Lawyers Association, all of us can come together and let's set up our own rules, that all of us, members of ILA, will never, ever file a pleading more than 15 pages in any court for anything. So Justice Kothari, how come we don't have a page limit in India?
We are verbose. Unfortunately, whatever these young friends are talking is very, very true, very unfortunate, but it is happening. And with my experience in judiciary for last 40 years, it is high time that we set time limits for oral arguments, and written arguments need to be encouraged. And about this case load, actually nobody really raises a proper demand before the government. There are two important aspects which are generally said: quantity and quality, both. The size of judiciary is also very, very less than what is required. It should be 10 times of what is now today, looking to the 5 crore cases which you are talking about. And the quality means training of the judges. They pass at the lower judiciary, they pass the exams and they are judges for lifelong. No worries about the trainings. A formality of every year going to Judicial Academy is taken and nothing else happens. High Court judges, and with great respects, do not bother about training part. It is unfortunate. I've been attending NJ when I was a judge for last 16 years. Now I'm a retired fellow, but I'm practicing again as arbitrator. And Ojaswita rightly mentioned that she would not prefer arbitration in India because of a variety of reasons. But the judiciary as a whole needs to push its load to ADR system, arbitrations and mediations. There are laws and frameworks in place, but sheer inertia, I would say, is there not to push the load of the cases from courts to the ADR system, arbitrations and mediations. That needs to be taken care. And we at bar councils and bar associations, I think except holding parties, we don't do any good. We are not talking academics. We are not holding academic clubs. We do not decide, we do not discuss the case laws. So we are just, I don't know where we are living like. And unless these reforms, and you rightly said, if there are law ministers, law commissions, bar councils, bar associations, what they are doing? They are not even raising proper demands to the places where they should raise.
Justice Kothari, does every state in India have a law minister?
Yes, every state has a law minister. Every state has a law commission, separate. Then the central law commission. But I don't know what is their output. We are hardly made aware by the news in the public domain that what they are doing. Except sometimes we hear that old laws are being repealed at their recommendation. What is this? Or the new laws are coming after so much of time. Whenever that is needed, that's not there.
So does a state in India have a power to fix its own court system within that state or no?
Yes. Even the courts have their own rules.
So how come one state can't fix the
number of letters and words and all this? They can be very well said. I remember distinctly, sir, when I was a judge, I even passed a judicial order that pagination, how it will be done on the files. 1 upon 200, 2 upon 200, 3 upon 200. This was the simple thing, and every top of the page will bear the title of that page. What is that page? Whether it is reply, whether it is rejoinder, whether it is main writ petition or what. This simple thing can increase your efficiency. These are not thought of. So we have typical bureaucratic attitude in our country, which needs to be just thrown out of the system.
Thank you.
And very simple kind of rules can be made, which should be followed by all. And I wonder why young lawyers are not discussing all this.
Yes.
They discuss in bar association, bar councils, and impress upon the chief justices or the law ministers of the state that please at least do this much.
Yes.
You can't take new judges immediately, fill up the vacancies, 30% vacancies everywhere there, right from top to bottom. Why it is so?
I think lawyers throughout
is secondary. Appoint somebody who is at least good at it.
I think lawyers throughout India should go on a strike one day and say we're not doing anything till you fix the following 7 things.
Not vote for you, gentlemen. Next time if you don't do this, we'll throw you out of work.
Right.
This is the best threat which they can give.
Right. Something has to be done. Durga, next.
Yeah, sure, Mr. Chugh. So, Rachna, I would like you to give your intro.
Yeah, hi everyone. Good morning. I am the practice head for the technology practice at Anagram Partners. Anagram Partners is a recently sort of flouted law firm. I think we're about 3 years old now, but it was started by the ex-GC of the Tata Group and ex founder of AZPN Partners, as well as the M&A heads of Nitish Desai. Yeah, over to you, Durga.
Yeah, yeah, Rachna. So, what do you think about this narrow election victory and the need for coalition support impact legislative reforms or policies related to the legal profession in India?
Yeah, I think thematically, I think we have sort of touched upon, the general observation, I think, in this group that, while it was a narrow victory, at the end of the day, the government doesn't look very different from what it was, in the last two terms. Granted, you have two coalition partners. From the perspective that I stand, which is from technology, I think it could not be a better government because one of the coalition partners happens to be the front runners of technology in India. Chandrababu Naidu really gave Andhra Pradesh the push that it has had. And while today we see Bangalore as the hub for tech, really Andhra Pradesh started the story with Microsoft coming in 1998, and all of the major tech hubs, whether it's Google, Meta, really having their workforce globally, I think, sourced from Andhra Pradesh. So overall, I think I think this is the best government we could have because we have somewhat of an opposition coming in place that can now challenge some of the obvious policies that we're going through. We're slated to have a new data protection regime coming in, and consultations on that subject is going to open up shortly. But you'll have a lot more participation now. Yeah.
So Rachna, I think you're saying that you would have been happier if Chandrababu Naidu was prime minister.
I can't say that.
Why
Because I
not?
don't
You just
think
said
we'd
it.
have stability. I think I would say that we're at a place where, it's good that you didn't have an overall majority, because checks and balances were missing from the last regime. But I think the continuity that this government can bring, because there was a lot, quite honestly, leading up to the elections as well. There was a lot of policy pushed by the mighty minister. There was a lot of policy pushed by the RBI in the form of various draft circulars, where you could see that the government was gearing up with work being done even before they were coming in. So I think in the next 100 days, you will see a significant amount of legal reforms, not just in the tech sector, quite honestly, but also overall. You have the labor codes coming in. You've recently had notifications where even in terms of procurement contracts, there's been a push for mediation over arbitration. So there is a significant amount of movement we'll see in legal policies in this year. So it is the best mix that I think we could have gotten from a coalition government, but with a strong opposition as well.
If you had a magic wand and you could change one thing about the Indian legal system, what would that be?
Think speed, as what everyone else has been saying. I think in India, we really lack a voice as lawyers to bring in speed, to bring in, some of the practical nuances that I don't think the government can envisage. I think as lawyers and law firms, and of course in-house, from a business perspective, while the government is very, vocal in hearing out certain parties, I think overall they seem to either lose out on protecting individual customer or individual rights, or they go swing the other way and they push for business reforms forgetting the customer. So I think for lawyers to be able to give a better voice and to be able to bring in a lot more speed and resolution, I think that's where I think if we as lawyers could push some policy with the new government, that's something that we should push.
Isn't finishing a M&A transaction on a scale of 0 to 10, how painful do you think it is to finish a M&A transaction from the government regulatory point of view on 0
I
to
think
10?
Yeah, I think if you're in an unregulated sector or where you have minimal nexus or engagement with the government, I could arguably say we've had deals close in 2 or 3 weeks. But the moment you have to go to a regulator, the moment you have to deal with, say, an NCLT decision for a merger, or you need a change of approval from the RBI, then apart from just getting those meetings in, you're also trying to balance the emotions of various regulators. So it's a little bit of a dance of, what do you present to them, how do you present to them, and, what is the climate? So I think, even in an M&A deal, the color takes the color of any, judicial proceeding in that aspect. So it could go as close to a year, in fact, for the larger deals.
So it's painful, right?
It is.
Okay, so what is one thing that could be done to reduce the pain in half?
I think streamlining processes, I think some of the issues that, say regulators really face, it's the same issue. As lawyers, I don't think those issues have changed. The questions have changed. So I think some streamlining of processes where, it is an
But
automatic
that's too
approval.
general and vague, streamlining a process. Give me one idea, one thing that could be
I
done
mean, I
that's
think you
easy
can
to do.
do, I think it's easier to just bring in some relaxations with these compliances. I don't think we should be going in for things that have cleared out, in terms of process. Like, for instance, change of approval for the board, right? You're going to make those corporate filings. Fit and proper, at the end of the day, the board and the company is cognizant that they don't want to have certain types of directors on the board. So really an RBI coming in and clearing this, or the government having a say from a media law perspective. We're not really sure why the government should have a say in how corporate structures are put in place, so long as, the company is meeting X compliances that are already predefined.
Yeah, you're right. And all these ideas, the reason I ask all this is that all these ideas are in everybody's head, all of you practicing out there. But we
Yeah.
don't have a system in India where there's conversation, right? It's not like there is the government law department or RBI is holding a session with lawyers like, hey, what can we do better or simplify? And if we simplify and make it easier, it'll be to everybody's benefit, right? Like change of board directors, it's pointless that the government has to approve or whatever. Let people do what they're doing. And I think the biggest issue I see different in India is that in other countries, 99% of the time people are following the law and 1% there are bad actors. So these countries have decided that no matter what, 1% of the country is going to be bad. So ignore them and then we'll figure out a way to put them in prison or capture them or whatever. But don't put hindrances to make the 99% of the people's life bad. With India, what I see is because they're worried about the 1%, they'll make the life of 99% difficult.
No, I mean,
So,
I agree with you, but I think you'll have to give it to this government in that we've started moving from, a lack of consultation to some amount of consultation. I think again, in the tech sector, the data protection bill has honestly been put together by lawyers in the
right.
stream. So in that sense, I think what I agree with you where I think these conferences, these consultations need to be opened up to a larger group and not a select set of lawyers that, do tend to get audience
So
more than
Rachna, I have a
others.
challenge for you. We'll do another ILA webinar next month on fixing and making the corporate law governance easier and faster and M&A easier and faster. Will you get me one speaker from RBI?
That will never, I don't think RBI, when they come in,
You
anything they say is policy. So RBI is very, very astute about what they say. And let me
you
tell
think
you,
we're gonna
RBI might
become
say,
you think we're
no,
gonna
let me
become
tell you,
a
RBI might say X thing, and we've seen that as Indian lawyers. RBIs will communicate X, and the minute they walk off that stage, policy Y comes in. And I think every regulated business that's ever engaged with RBI, lesser with SEBI and IRDA, but with RBI has, experienced that. So much so that businesses in India today have ex-RBI officials as their advisors. So I don't think there's any usefulness in hearing on RBI. Where I do think policy needs to come in is more from a central government perspective, which I think they've started doing.
with
We
their
cannot become a first world nation if we're only going to be looking at the central government for everything in our life. Power has to be in Mumbai for the Mumbai lawyers and Maharashtra for the Maharashtra lawyers. And we've got to stop doing this Amitabh Bachchan thing of looking at one person as leading the country or one city or whatever. Anyways, thank you so much. Durga, next.
Thank you.
Thank you, Rachna. Thank you so much. So, now I request Jay sir to introduce himself. Hello.
Hi, I'm just Jay. I'm
Yes.
not knighted yet. Yeah, it's just Jay. But thank you for inviting me. And I work with a law firm called Legal Logic, which is based out of Pune. It's a service law firm. And as a young lawyer, I'm part of a team that deals with new laws. I'd say most of the laws that I work with or I aim to work with are not laws yet, or are just laws, right? But yeah, I come with a lot of hope and optimism, looking at how this new election will come change, or what's my wish list and whether it has been fulfilled and whether the new government is going to fulfill it. Right? As a young lawyer, there's a lot of optimism and hope. Yeah, over to you.
Okay. Thank you, Jay. So, Jay, what do you think the new government approach will be towards issuing the personal law, civil liberties, or human rights impact on the legal landscape in India?
Right. Perfect. So, I think in terms of the current government and the past two governments that have been there, I definitely had a wish list, so to say, right? I'll go back to an anecdote and then talk about my wish list. So, as a young lawyer, or still young, but I was interning with Himachal Pradesh Legal Services and had the opportunity to sort of interact with some of the justices of High Court and District Court. And in one of those, and there was easy access because I was interning with one of the district court judges. So I went up to them and I just had a jail visit, and I told them that there are a lot of people in there who are complaining that their cases are not getting filed or expedited over a long time. They're not getting lawyers and all those things. So, and I was young and quite not concerned about how that would come up before those judges, right? And so one of the judges called me over and he said, "Ki, come back to my courtroom next day, and I'll give you a pile of cases, and you tell me how should I finish them." And I was there the next day, and I could see the piles of files that were there with them and their priorities, and I could understand. I mean, after I saw that, I realized that that's not where I want to be, right? And if I look at some of the laws and I try to explain to someone that, okay, your particular situation is going to be governed under a Telegraph Act, and they tell me that telegraphs are long gone. So in terms of, and that's where the decision was to not look at the older laws, but look at what's there in the future. And in terms of wish list, definitely some things have changed. There's new criminal laws that are out there, which do relate to the matters or problems that I see in front of me, and somewhere they're being acknowledged. There are new laws around how individuals will be treated in the digital space. Uh, there's also talk of a uniform civil code, which again talks about the society as it is right now, and whether the law should change and adapt and be relevant to someone like me who doesn't even relate to some of the laws that we see here. So in that sense, the government has been delivering, repealing older laws, trying to bring in new laws. But I think the devil is in the implementation part of it. While the laws have come in, how will they be implemented? Whether they'll actually improve an individual's life and their access to justice and uphold their rights is something that we have to see, and there's still optimism for that.
So, Jay, you're a young lawyer, you said. So, can I request a favor that in the next 10 years, can you get the Maharashtra law minister to attend and speak at one of the ILA panels? Is 10
So,
years enough?
depends on what happens in the legislative elections, actually. So there is currently the law minister, and when you asked that question, I was curious, so I'll be open about it. I did Google who it is, right? And it was Mr. Devendra Fadnavis, who is the law minister for
The
Maharashtra.
former chief minister.
And
Right.
if he does continue for the next 10 years, we'll have him on this forum.
So you'll try starting tomorrow?
Yeah, definitely.
Okay, good. Durga?
Thank you, Jay. Thank you for your inputs. So now I request Vasundhara Shankar to give her intro, and then we'll follow with the question.
Sure. Thank you for the introduction. My name is Vasundhara. I am the founder and managing partner of a firm called Verum Legal, and we primarily work with startups and tech companies. So just to start with, a lot has been discussed here, a lot of very relevant points, a lot of very important issues that, definitely need to go out of this discussion panel and be executed as well. I completely agree with, incorporating a lot of changes that have been discussed here, especially with respect to the procedural aspect of how law is being practiced today in the country. My biggest, concern and the challenge that I think really plagues the Indian legal system is definitely pendency and delays and all of those issues that are causing those concerns. And the suggestion of maybe limiting the size of pleadings, maybe putting a timeline on how long a particular type of case should and can go on for are very good suggestions. My 2 cents on this before the questions posed is that I genuinely feel like more lawyers, more stakeholders, like relevant stakeholders, need to be involved in policy making, in creating legislations. We are still, very proud owners of just one law in the IT sector, which has come out in the 2000 year, and it is. It suffices to say that it is not a very, sufficient piece of legislation in today's world, especially with artificial intelligence coming into picture. Thankfully, we have a data protection law, which was definitely a need of the hour, but there is a lot to be done in that space. Because I work with technology a lot, and we also work with a lot of fintech companies. Honestly, RBI at this point seems to be the only body, government body, which is seeking any impactful changes, or there may be cumbersome, there may be too many, or to be kept a tag on, and they're definitely providing a lot of space for innovation to the fintech sector. But yeah, that's probably the only government body which is proactively creating laws. So maybe more needs to be done on that front. So Durga, yes, please go ahead with whatever question you would like to ask.
Thank you, Vasundhara. I think you're pretty much covered, but now I would like Mr. Chub to pose a question to you.
Sure.
So what does Verum Legal mean, Vasundhara?
So Verum actually stands for truth in Latin, and we started off. I mean, I've always had an inclination of helping people with their human rights, and helping the people who are in need of help with legal assistance. We also have a legal aid department, where we kind of work with NGOs and people who need free legal aid. So we do a lot of pro bono work as well. That's where the idea started, and then I kind of got into the technology side of things, and we have also worked with a lot of tech companies.
So you went to London School of Economics, right? For some course.
That's right.
So I'm sure by osmosis you learned some economics, right?
Little bit. I mean, I had economics in law school as well because of my BBL.
So somebody once told me that 90% of the lawyers in India have per capita income that's lower than the average per capita income of India. What can we do from economics point of view to not have 90% of our colleagues earning less than the national average?
No, that's definitely a concern, and that concern, became even more obvious during the pandemic when we had so many lawyers, losing their practice and not being able to earn their living. So As has already been discussed, perhaps creating more awareness with respect to how legal services can be attained, because there's definitely a gap. There are people who are not able to find lawyers, and then there are lawyers who are not able to find work. So, maybe contingency-based fee structures where people who are not able to pay outright, like especially in recovery cases, where if a lawyer is helping a person who's not able to afford legal help, gets the case through and gets the recovery amount, recovered, the amount recovered, then should be able to get a contingency-based fee on that. Could be one aspect. The other aspect could be helping them, maybe also allowing online appearances. I feel like that was a very important development that happened in the legal fraternity. Unfortunately, we didn't stick through with it after the pandemic. But maybe courts can provide a good legal online infrastructure in the courts premises itself, where people who don't have access to online platforms or laptops and devices can use that, appear across the country. I mean, we saved a lot of time, we had a lot of access, and I feel like that can definitely help lawyers who are not in a position to maybe travel for more work and gain access that way. As well as, I mean, I genuinely don't think giving away monthly amounts or giving away freebies to anybody is a sustainable way of helping people make a living. Like giving a stipend, for example. I don't believe in that being a very sustainable consistent way of helping. So giving more opportunities and making those opportunities accessible to people is what is definitely important. So I mean, maybe those couple of those things can be done where the filing process can be made easier, so more people are able to file more cases, are able to approach the court better, and yeah, so on and so forth should be able to help to start with.
But clients don't want to pay, right? Because when we bill our clients for 6 hours of getting a continuance and there's no justice, then the clients don't want to pay. So the judicial system has to be efficient and working and granting justice, and then the lawyers will get paid.
Absolutely. And clients don't want to pay for a case where they've already lost money. So say, for example, I've already lost a couple of lakhs. I don't want to spend a couple of more lakhs to get those couple of lakhs back. So contingency based, which happens everywhere in the world except in India. I understand the concerns that may be carried with that as well. So maybe the contingency based approach can be allowed in certain types of cases, especially commercial disputes, where everything is just about money and not a lot of ethics or the penalties or forms of law involved. That could really help.
Article 19G says no restraint on trade. Oh, how come it doesn't apply to lawyers? It applies to everyone else.
Absolutely.
Durga has a question for Kulwant. Durga, you muted. Durga, you muted.
Yeah,
Okay.
thank you, Vasundhara. Hi, Kulwant. So Nikhil sir has already shared his view on this. I want to know what steps should the legal community take to ensure that the interest of marginal communities and vulnerable section of the society are safeguarded under the new political dispensation.
And also introduce yourself.
Yeah.
We can't hear you, Kulwant. We can't hear you, Kulwant. Okay. No. Who's next? Durga will come back to Kulwant.
Yeah. Yeah. Very sir, would you introduce yourself now?
Thank you very much, first of all, to the entire team who have given me the chance to speak in this webinar. And at the outset, I would also like to thank to the team of Chug team who initiated the previous similar webinars on the similar topics. So myself, I'm running my law firm in Punjab. It's named Ferry Thiman and Co. And I'm primarily I'm dealing in corporate laws and taxation. So I think I would be helpful for any insights if you would like to ask in the dice. Thank you.
So, Sir, in what ways can the legal profession adapt to and influence the policies shift expect from the new government to ensure a fair and legal framework in India?
Yes, it's a very good question. First of all, I would like to apprise you that 3 or 4 major policies, what you call policies or act, already have been changed. If you are aware about the IPC, Indian Penal Code, it has been changed into some Hindi language. It is called Nyaya Sahinta, if I'm not wrong. Another is Evidence Act, which is again named in Hindi. But somehow these are depicting that we are going into some era of changes. On the other hand, my view is that we need to address India on international platforms. So there is no much benefit of changing the law in Hindi or something like that. And probably there are some benefits like we were following the footprints of British era, in which few of the offences were under under very meager or less fines were there. Some of the acts and rules were followed from the old age systems. So if you happen to see the Evidence Act, which is now changed, and the Nyaya Sahinta, which is Indian Penal Code, and another evidence apart from that is Civil Code is also changed to a great extent. I think it is in the annual, it is going to be initiated in the month of August. The Law Ministry is going to initiate the new books which will be applicable in the legal system. One is this step this government has already taken. Another policies which we are expecting, because I'm a corporate lawyer and I'm running my law firm, we need to address some of our problems, which Mr. Chug has already told us that we need to bring the platform of entire justice online. Some of the steps, as I already said, have been taken. Supreme Court is now, if I'm not wrong, all the links are available online. In our Punjab and Haryana High Court, I think there are 70 courts. And I was happy last week when we were attending the bar meeting. It was told that all the 70 courts are now online. You guys can ask me the link, and we can, on a real-time basis, we can hear the pleadings, and we can jump into the dice for any of the matter. Like if some client is, if some senior client is sitting in America, and they have some property in Mohali or Chandigarh, and they cannot commute in India for that matter, they can, with prior approval from the court, High Court or Supreme Court, they can appear online. And if to add my point in a more vigorous way, if I am not wrong, during the pandemic, there was a standing instruction by Mr. Chandrachud, CGI, that India strongly needs to be taken some tech laws now. AI, AI has been started to be used by various courts right now. The orders and the draftings have been, started to be used on an AI platform nowadays. So the system, the sound system and the video, which I'm talking about in the courts, are properly installed by taking the tenders from high-end software companies. Previously, the courts were managing all the things with some, low quality cameras and sound system was there. I'm talking about the pandemic period, because that in that scenario, I think all the things were taking place in a very haphazard manner. People were managing the things so that their legal rights should not hamper during this period. So the policy changes I'm talking about is the AI system, the drafting, and no doubt Mr. Chug said that there are some instructions which are very much fine as compared to US laws, like the paper the size of the paper, the limitation of the pleadings, the manner of presenting them should be very much adhered to in India, likewise, so that we can put India to the international platform. And from my personal point of view, sorry, yes, Mr. Chuk. You're not audible, sir.
You're in Punjab and you're a tax lawyer, so I have to ask you this. Is it fair for a country that should be fair? Is it fair that a Punjabi farmer who's very rich and successful and drives a Mercedes doesn't pay any tax?
Yes, there are, if I go deep down into the technicalities of the chapter, yes, there are some sort of tax tables for the extremely rich agriculturists. Their income is supposed to be clubbed in the normal income. Suppose they are selling the milk, or suppose they have some of the machinery which they are giving on lease, something like that. They come under the realm of taxation. But so far the middle class agriculturists or the small agriculturists are concerned, I think they are outside the purview of the agriculture laws, or sorry, taxation laws. And if I go to the crux of the question, that people who plan to, under the garb of their status as agriculturists, they pose themselves as an agriculturist, and to curb the tax liabilities, they sometimes misuse the policy of the taxation in India. So I think taxation authorities need to take the steps in this regard very strictly.
Yeah. Don't you think we should have a fair country and everybody should be treated equally? And first 100,000 rupees, 1 lakh rupees not taxed anyways. And that should be true for every single person, no matter what business they're in, right?
Yes. To give more support to your question, I would also like to add that in India, the taxation system is not, social supportive. If somebody keep on paying the taxes for suppose 7 or 8 years, in return he does not get any sort of social security like insurance, or old age pensions or something like that. It should be supported like that. So unlike other countries, if we talk about Canada and USA, there are so many social securities for the taxed person. I think that's the reason why the brain training is going on from India to other developed countries. This is a major reason.
Yes, Durga, who's left?
So thank you very. Yeah, Prachi is left and Kulwan.
Am I
Akshar.
audible? Am I audible?
Yeah. Now you're audible, Kulwan.
Thank you.
Yeah.
So just a
Thank you.
system issues. Yeah, please.
Yeah. So
Can I
Kulwan,
jump up if you are want to go to
yeah. Kulwan, can you introduce yourself?
All right. So I'm Kulwan from Tempest Law Associates based out of Hyderabad, and we are into it's a law firm, and we are into a lot of practices. The key practices are M&A transactions and the real estate litigation. So we have a esteemed team of experienced associates, and the founder partner, Mr. Ravi Prasad and Ms. Sundari.
Thank you, Kulwan. So now we would like to know your views on this election results and its impact on the lawyers.
The elections are, it's a political system, a democratic way of electing the government. But being post-independent, we have seen a lot of things happening in the legal scenario and the judicial system. Let's be very positive about it, that there have been a lot of positive changes over the years that we have seen, and the new fresh thought has come up to, and the conversations and the way that we are interacting right now. There's been a lot of committees being set up in the past and has given good guidance to the government and the recommendations, and those recommendations have been followed. So what we understand, I think most of the our key panelists have taken up those issues very well already, and I heard all the reforms and the that needs to be introduce into our system. The very first thing which I would still say, coming back to the point where Mr. Chugh has raised about the number of pages, so that change needs to be brought right from the education system. So we have interns coming. I mean, as a law firm, we have interns coming every month, and what we realized in the 5 years of their graduation, believe me, they are absolutely clueless about the industry, and they're not industry ready at all. So it's a flaw in the education system. And also coming to the pages, number of pages, you need to understand the pattern of the education system all forces them to fill up the pages, like the maximum 10 pages they have to finish however they want to, right? So that mindset needs to change from there. If you really want to bring them and come to the conclusion where they can actually report it in a crisp, clear language in the minimum words, but they are not even designed or equipped right from that stage. So how can we actually take it like after practicing for years, because they've been designed from the beginning? That is one part, right? Coming to the judicial reforms, because that is also one aspect which we have been talking lately. I want to touch upon the jail reforms also. That's an integral part of the judicial system, because that's the result which most of the people are suffering with, right? So jail reforms are something which we really need to understand and take it up. And it's you can't make it that it's a subset of our judicial system, right? When we speak about it, it's not just about the judges, it's not about the cases, it's also about the people who are suffering and being in the jails for years and years, and their hearing has not been. It's a humanitarian thing which we really need to take it up and do more things on this for the jail reforms. That's what my primary concern is here now, because I know that most of the topics have already been taken up. And yes, I would like to actually bring one again and reinforce the point about the cassation benches apart from the Supreme Court, because we have one centralized place as Supreme Court for all the matters being taken at one place, whereas we should actually have more cassation benches in most of the metro cities, at least 4 to 5 in India, given the geographical dynamics of our country and the more than 1 billion population that we have. It is much needed now.
How about every state should have a Supreme Court?
It's practically not possible, but every state has law ministers, and we know that because I'm in Hyderabad, and I've been into the meetings and conferences where the law ministers were also invited. So I know the ideas that they've been sharing, and the roadmaps they have been sharing, the government, the previous government also. So
Kulwant, we went to the moon 60 years ago, and now you're saying we can't have a Supreme Court in a state?
Not every state at least have 3 or 4 different pockets, not the Supreme Court, sir. That will stay there as a constitution bench, but I'm here. It's not my proposal. Trust me, it's already been a committee which has proposed to the government long back. It just need to prioritize and given an importance. That's what I actually am suggesting right now.
With 1.4 billion people, there should be a Supreme Court for at least 1 million people each, right? That's 14,000 Supreme
No,
Courts.
we have a very structured judicial system where there are the lower courts which are taking care of all the matters. Then it goes to the next level of court, and then we have high court. What I'm talking about is those matters again sitting at one power center, that is Supreme Court, and it's being lagging. Lot of cases are sitting there, and just imagine the number of cases a Supreme Court judge has to deal with on everyday basis. So some cassation benches kind of a model that we can come up with.
We have former General Counsel of Tech Mahindra, Mr. Atanu Sarkar, in the audience. Mr. Sarkar, I don't know if you can hear me, but do you have anything to say on how we can fix the legal system of India, given that you were General Counsel of one of the largest companies in the country, employing 150,000 people? I don't know if you can hear me.
And something else.
Actually, yeah, he can hear us and he's also a presenter now. So you can just
Okay.
unmute yourself, please.
Muted. Okay, we'll get Mr. Sarkar ready. In the meanwhile, we go to Prachi, Durga.
Yeah. Thank you, Kulwan.
Thank you so much.
Yeah. Hi, Prachi. So, short
Hi.
intro. Yeah. Can you give us
Yes,
short
good
intro?
afternoon, everyone. Yes, thank you so much. I'm very honored to be here. So I am a practicing advocate in Nashik district in subordinate courts, and I do some appearances in the appellate side of the Bombay High Court.
Yeah. So, Prachi, already most of the speakers have given the answer for this question, but still, what are the key legal reforms you think should the new government should take to prioritize and strengthen the judicial system in India?
Okay. So I know quite interesting inputs have been given by the earlier panelists, but what is lacking since the last 10 years is there have been a lot of laws and bills that have been introduced, but the implementation of it is nowhere to be seen. So to begin with, the National Litigation Policy, it's actually the brainchild of the UPA government, and it's been pending since 2005. Now, from a recent New York Times article, I got to know that the 50% of pending cases in the Supreme Court are by the government itself, the central and state governments. So that puts a lot of burden on the Supreme Court because half of its time goes in litigating the state's cases than the ordinary people's cases. So if this national litigation policy is actually implemented, a lot of government cases would be reduced because the ADR system would be introduced to solve cases between the states, the state litigants. And that will give a breather to the Supreme Court to take care of the cases of the ordinary people. In fact, there was a manifesto in one of the parties this time that they would like to have a separate bench of the Supreme Court to deal with the constitutional matters and a separate bench for the appellate matters, which I think is a welcome thing and should be discussed further. Because of this, there is the cost of litigation. Because I come from the lower courts, I know most of the litigants are actually afraid of approaching the High Court and the Supreme Court. The starting charge of a Bombay High Court lawyer would be not less than 50,000 rupees. And most of the litigants from the lower courts, they don't even have the per capita income where they can afford a High Court lawyer, wait for those 2-3 years to get their justice or whatever, order or the verdict. So they don't go to the higher courts at all. And that's the reason why, as Kulwan said, the jail reforms. So 77% of under trials are still in jail because they cannot afford to approach the high courts for bail hearings. The second thing that I have observed is in the last 10 years that the lower courts are hesitant to give bail orders in a positive manner. In fact, recently in Rouse Court, it was heard that one judge said to his clerk, ED matters mein bail kaun deta hai? And the wife was the accused was there, and she took this matter to the PDJ and she transferred the case. So this is the mentality of the judges here. They do not want to give bail in economic offenses or any matters with heinous offenses. In fact, Justice Chandrachud also pointed this out, and this is coming from somewhere at the top. If you see most of the Supreme Court cases these days, they are very case specific. So the authority of the Supreme Court as a court of precedence is somewhat being lost because lower courts are not confident enough to give these bail matters. And so, because of that, a lot of bail matters are pending. And hence, a lot of criminals are in jail. This is, increasing the occupancy in jail also. It's very inhuman. In each cell, you can see about 8 to 10 accused being lodged, and they're not even since the pandemic. A lot of things have been digitized, so most of the accused are presented through Skype or some kind of video conferencing. They are not even brought outside of the jail. At least they had that breather when they were appeared before the court. Now even that is not happening. So that's the second part. And the third part that everybody's talking about, the increased digitization, which is all good and well for the higher courts, because it's a court of just appeals, so they only have to deal with arguments. But in the lower courts, you can digitize, you can give files. But what about witness hearings? For the judge to see the witness, they have to appear in court. That is not possible, and we saw that during the pandemic, a lot of courts couldn't function properly because it's not just about arguments, right? The evidence has to be taken in. This is not possible. So the digitization process is not very much feasible at the lower courts. Also, if you go to some tribal areas or if you go to some very remote rural areas, you don't have computers. You don't have the internet facility. How are even those tribal or those poor litigants how do you expect them to even see the cases online? It's definitely not possible. And one last thing about the new laws which have been introduced. Well, yes, it's a welcome change, and I do know that some 1,500 laws have been repealed since in the last 10 years, redundant laws, which is a welcome change. And as far as the new 3 laws are concerned, it is said that 80% of the laws, the matter in these laws is similar to the older laws. I would just say it's an old wine in new bottle kind of a thing. But nonetheless, it's a step forward, and we hope to see that these laws would help in the expedition of justice. It's over to you.
Thank you, Prachi. Mr. Sikar, good to see you.
Yeah, same here. Thank you so much.
You graduated from my hometown of Nagpur Law University in the 80s. You were General Counsel of Tech Mahindra for 14 years and have been practicing law for a long time. I think you have a very good idea. So if some magic wands are handed to you, what would you do to fix the legal system of India?
Okay, and I think, Navneet, what you did not do is to tell everybody that I've hung my boots since. So I'm no longer, I've just been doing some pro bono work, and that is what I've been into. Otherwise, I've hung my boots from the corporate as well as the profession. But yeah, I think it was a wonderful discussion. I've been hearing everybody on this call in some very, very valuable inputs. But I think one of the things straight away to pick up, Nikhil made a valid point on lower judiciary. And I think that is where I come from. I started off my life from the lower judiciary. And today, if you were to ask me, I find that lower judiciary is thrown under the bus at the earliest opportunity. I think the Supreme Court or the High Court, they have to own up what the lower judiciary is doing. They just cannot be throwing. So this is what's been happening. Instead of somebody owning up, I find that they find it more convenient to be throwing the person subordinate under the bus. So that is one observation and my feeling, because I started somewhere in '84 as a practicing lawyer from the lower courts. And I think, to be fair, I would think, Navneet, you talked about pleadings. Pick up an old conveyance in India, you would find that will not exceed 4 pages. Pick up a new conveyance today, drafted, it'll run into hundreds of pages. I don't know why. Okay, either people do not know how to draft, or they have not been taught how to draft, or they find it more convenient to be adding pages and pages. I cannot, that's my take. I think some of the observations I think personally, talking about some quick points I would like to make is new government. I do have some expectations from them and more than before, especially because of Chandrababu Naidu. I think the point Rachna made was very, very valid. And he has been one person, I don't know whether people would remember or not, 95, 96, he was the person who gave a complete different complexion to the Hyderabad High Court and the judiciary. He was the first guy to introduce under trials to come through video conferencing and all these kind of initiatives. I mean, I'm not saying right or wrong, but he did try to bring in these kind of concepts. Unfortunately, it's a different story that it didn't last long, but these were some of the initiatives. And therefore, I do have a lot of expectation from it. Now, one of the other points that you made, it is law ministers vis-a-vis judiciary, vis-a-vis bar council. I think that is where we are caught in a bind. Because these three, absolutely, they're three different bodies and they all have to be on the same page. I think the law minister can do nothing if the judiciary were to stonewall them. Similarly, the judiciary also cannot do anything. So it is all a bar bench government. It has to be a collective move. So that was another one I wanted to point it out because, it's just the law minister alone cannot be doing anything. It has to be a collective move. And coming on to the in-house lawyers, since I spoke about, I've had an in-house tent. One of the baby steps that the in-house lawyers, I think, which must begin on high time with the globalization, is to create some kind of an institute or an society, what you have for the chartered accountants or for the company secretaries. And one of the first things I would be looking at is a privilege cover being extended to all the in-house lawyers. Because we have walked into an absurdity where an in-house lawyer in US, an Indian in-house lawyer in US enjoys, for a matter in US, enjoys privilege, but a matter in India does not enjoy privilege.
Right.
So these are kind of things, and I would think these are small little things where we need to begin with, if we are at all, because asking for the sun and the moon may not help, but let's take baby steps.
Right. Like somebody said, take care of the small things and the bigger picture fixes itself. Thank you so much, Mr. Sarkar. You were not prepared. We did not give you time, but you gave such wonderful feedback. And I earlier invited him to come speak, and he said, no, not me, and I'll join.
I think that was a very wise decision. After hearing everybody, I think it is a good thing that I did not speak, or I did not take that assignment, I would say.
Okay, so I'm going to give you a tougher assignment. We'll do a webinar next month and get a bunch of in-house counsels, and you'll give them a speech on everything they're doing wrong.
I think they're doing a lot of right things too. I think let's focus on the right things.
The right things are happening anyways.
The role of the in-house lawyers today have completely changed what it was 20 years back and today. I think it's completely. And I think legal law as a profession, I would think it has evolved over the last 25 years. And it's very different. I mean, we talk about even the legislations. Yes, there are, I wouldn't say everything is perfect, but there has been some great moves. And I just hope that the implementation and the administration is proper, because that is where we need to build the capability and the skills. Because I find a lot of laws, etc. I think the skills and capability are not there. And another point I wanted to touch, I'm sorry, I'll just take a minute. We were talking about earnings of lawyers. Can I talk about that, please?
Yes, please.
Because, I'll tell you, I find the councils, senior councils, when they raise their invoices, they would charge 10% clerkage. But why can't they charge an X amount for the junior who's assisting him? I'll tell you, this is just an observation. Because I find that today, if I were to, let me just throw this up for everybody. I would think a good lawyer is known from the chamber he has come from, and that speaks volume of the chambers. Let us say Bhabha or Kanga's chamber in Bombay. Look at the number of people. The best of lawyers have been churned out by that chamber. So, it's a reciprocal game. I think talking about the litigation lawyers, I really feel bad for them at times because the juniors, I wonder whether they are really taken care of or not. And this is where only those juniors, those who have the safety net, those who come with the safety net, can sustain those first 5 to 7 years. Otherwise, it becomes an absolute, one hell of a, I would say bummer, I would say. So that is my observation. I don't know whether others would agree with me or not, though coming from an in-house role, but I would think this is something the seniors, they owe it. And the last one I wanted to touch upon was the structure of the judiciary. Somebody did talk about Supreme Courts, and even you did mention. I would think we have had a very good, the legal structure in India has been very good. Only difficulty is that today the Supreme Court can spend 7 days to hear an interim bail application. I think, should the Supreme Court be doing it? That should, if they have to give an interim bail, give it in 10 minutes' time. I can't see why the Supreme Court ought to be spending 7 days to grant an interim bail. It's just not, I think the Supreme Court is also not efficiently utilizing its time. Earlier, if I were to go back in time, there were hardly few matters which would go to the Supreme Court, and High Court was absolutely the ultimate. It would literally come to a stop over there. Sorry, and that is my view.
Thank you. Thank you so much. We have to call you back. Wonderful ideas. I don't even know why the government is in the business of creating Brahmins and other backward classes in the legal community. Lawyers are lawyers, and there should be no such thing as a senior lawyer and junior lawyer. I don't know how this started, and if a private company does it, it's another thing. But it's the government giving this discrimination, which is kind of sad. But we'll come back. We'll do a senior advocate session one day. Thank you for everybody in the audience. We are also Facebook Live. So thank you there. And then our entire presentation will be on YouTube. So all of you pass it around to your friends. Thank you to all the panelists for a great job. I really, really appreciate it. And thank you, Madhura and Durga, for putting the panel together. Thank you. God bless you all.
Thank you. Thank you very much.
Have a great day.
Thank you, everyone. Thank you, sir.
Thank you.